first disadvantage is the fact that presently prenuptial agreements are not binding upon an English family court. So you might have gone to the expense of say, instructing solicitors to prepare a prenuptial agreement to find out later on that most of it or part of it isn't upheld by the court. Number two, I put here in terms of aged prenups. It might be that by the time the court sees a prenup, it may have been many years since the prenup was signed. And the court might take the view that it doesn't adequately provide for, say, the best interest of the children. So that could reduce the weight the court might hold to the prenup. There might be, depending on the background of the individuals, a choice of jurisdiction clause. Now, you may have a clause to say that how your assets are to be divided is in accordance with this particular prenup, in accordance with the laws of a particular foreign jurisdiction. That clause does not bind the English family court. Now, there are certain countries, jurisdictions, which under their family laws, prenups are enforceable, but we're not there yet, or we're not there in terms of our English family court. So what the court will do, obviously they will have their own assessment to assess whether is this prenup fair or not. But by having this jurisdiction clause, it is evidence to the court that the parties intended to be bound by the agreement, because in that particular jurisdiction, they would have been bound by the agreement. Number four, and this is quite important for us lawyers, is that there's no crystal ball. We cannot say what will happen in the future. We cannot say whether the court will uphold the prenup. We can make sure we do all the things which we are told or advised to do, but the prenup may not cover all circumstances. There may be a change, there may be an illness, there may be a disability, loss of work, or an unexpected child. And unless the prenup covers all these circumstances, there's a risk that, again, if these events are not covered in the prenup, it reduces the weight the court might hold to the prenup. Number five is a review clause. Now, we would often advise clients that there should be a review provision, and this could take place upon a significant event, say a birth of a child or bankruptcy, or maybe on the 5th anniversary of the marriage. But this in turn can create difficulties because, one, if you are going to go down the lines of formally revising your prenup, there may be the costs and legal fees incurred. There's also the potential that there could be further disagreements between the parties, which can then put a strain on the marriage and the relationship. Number six is in relation to people just find it unromantic, or some people say prenups undermine the institution of marriage. And you're asking someone to enter into a prenup at a time when the couple are madly in love, planning their wedding, and now they have to go and see solicitors and be advised what would happen in the event there are divorce proceedings. And this also, I suppose, follows on to number seven, which is timing, that practically the couple are busy preparing for a wedding, and there's all those pressures and stresses involved. They may have financially committed, they may have paid deposits for their venue and other essential expenses for a wedding, invites might have gone out, and now they've been asked to sign a prenup maybe 28 days before the wedding. That's why it's so important to try and do it way before the 28 days if possible. And all of those discussions, again, can put a strain on the relationship. Number eight is in relation to the person who's perceived to be the economically weaker party. Now, the question is, are they vulnerable? Do they agree to sign simply because they want to get on and get married and get on with their preparations? And that's why it is so important that both parties have independent legal advice. They're fully aware of the implications of each clause in the prenup agreement, so that if someone is vulnerable, they have that breathing space, they have that time to reflect on what they're about to sign up to. Number nine is in relation to family members. It might be implied that if you're asking, and this I suppose maybe from parents, that if there's a request that their son or daughter sign up to a prenup agreement, is it being implied that their son or daughter is trying to take advantage of their partner, of the other intended party, because they might be financially stronger? And those sorts of discussions could again put a strain on the relationship of the couple. And lastly is parental pressure. You know, I'm sure many of us lawyers will know that quite often parents are the driving forces of some prenups, especially if it involves family wealth or if their son or daughter has acquired wealth in their own right. And you know, they really do push for a prenup in certain terms. And what can happen is that parts of the prenup are really reflecting the wishes of the parents as opposed to what the couple may intend. And those discussions again can put strain on the relationship and maybe strain on with other members of the family.